The Law Matters. Welcome once again. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this program has been created to educate, inform, and help you decide how to protect yourself, your family, and your business when it comes to law matters. It's information and resources that'll help you to decide whether or not you actually may want to handle some issues yourself. If you don't and you want to seek legal counsel, hopefully you'll be better prepared and therefore be able to help the legal counsel you select. Always our goal is to help you achieve the best possible results, save time and money as well. We, as always, want to welcome once again and thank our legal eagle, David Bizarre from the Bizarre and Associates Law Firm in East Providence, as he continues to weigh in on the legal issues that we tackle, sometimes providing funny and interesting anecdotes as well. So, August 14th of this year, the U.S. Department of Education finalized the revisions to Title IX of the Education Amendment of 1972, which governs discrimination on the basis of sex in higher education. In practice, Title IX does lead to parity in men's and women's athletics and also provides the standards for academic institutions who are receiving complaints about sexual harassment or domestic issue, dating violence, stalking, or whatever by students. For those of us who went to school back in the 70s, Title IX was an issue, and it was mostly focused around women in sports. That's expanded, and of course Brown was hot then. It's back in the news now, so we're going to discuss that. It's been going on for decades. So today in the news we will discuss what's been going on, and also because there are these new final revisions to Title IX. So David, the news was recently, as reported in, I guess it was Rhode Island News today, it says the Brown University reinstates 2 women's sports teams to comply with Title IX. It then became national news, and it was about fencing and equestrian to be being reinstated. Well, that's good and that's important. Give us a little background, as you know it, about Title IX.
So when you say on the basis of sex, you of course make me think right away of Ruth Bader GInsberg.
I hoped you would say that.
Well, of course, and it's what she built her legal career on as a law professor and lawyer before she became a judge.
Yes.
And so it's basically her position that she took in what became the law of the land is that you can't discriminate on the basis of sex. And then that was codified in Title IX, and it became the law. And of course, as you said, it became mostly focused originally around sports and women's sports, and Brown had its case back in the day, and I think it was the same lawyer, I think it was Lynette Labinger who had that case.
Yes.
And Brown had been brought into line with what was required under Title IX at the time, which is basically that men and women have to have equal opportunity to participate in intercollegiate sports.
I have to add in, Ruth Bader GInsberg went to Wheaton, my alma mater, of course a few years before I did, before she went on to Columbia Law. But
Harvard first and then Columbia.
Yes, thank you. So they talk about the new rules, regulations. Help us understand the differences or the distinction between what we're going to get into, namely that new rule, as maybe you might have state or federal legislators make their law. What becomes constitutional? What can they challenge? Did they challenge a regulation? And if Brown was challenged decades ago, it's been lingering, nothing's happened. What's constitutional here? What has happened?
Well, there's a couple of different things all built into that question.
Yes.
So in terms of Title IX and Brown, it's a compliance issue. And Brown had been in compliance and was following all the rules that it was supposed to follow based on its settlement in the 70s or whenever that actually happened. And what happened was, I think there were some changes in what programs they were going to have because of costs. And, you know, coronavirus didn't really play into that, but in any event, it could have. But the bottom line is that some sports had been eliminated, and it was brought back to court. Brown was brought back to court again because the elimination of certain women's sports they didn't feel was in parity with the elimination of certain men's sports. And I know Brown had eliminated some men's sports too, but they brought some back. And so the challenge was Brown in compliance with its settlement agreement and also, of course, with Title IX. And so what ended up happening was the latest settlement, which brought back two of the sports, fencing and equestrian for women.
So there's always an issue about budgets. There is a finite pot of money that's donated to that the athletic department governs. And so prior to this, that pot went to all the boys in whatever their sports were. It certainly made sense that they would try to bring women in, but they had regulations. There was no consequence for them not doing that for years until this came into play. And even when they called the regulation and a consent decree, there were times they were in compliance, times when they weren't. Now they were. Then they changed the relative proportion of boys to girls, the money that was available. Why wasn't this? Why is a regulation not just the same as it is law? You will have this proportion and that proportion, 50-50 or whatever that works out to be. How could that go on for so long, David?
Well, all laws are the law, and
yes.
Not all laws are complied with.
Yes. Okay.
I can just think about driving into work this morning, and I was doing a little bit above the speed limit on Route 4 as one car after another went right by me. And so were they in compliance with it? No.
Certainly not.
But until somebody says, hey, come over here, I want to talk to you for a minute, usually with a flashing light, that's people aren't always in compliance with the law. So if a university, and we don't have to pick on Brown, it can be any school. Isn't in compliance with Title IX or any other rule, law I should say, then someone can challenge it and say you're not in compliance with the law, and that can be litigated to determine whether they are or they aren't. And so one of the questions you asked is, well, what about other rules, regulations, laws passed by the state or the federal government? Are they constitutional or not constitutional? Well, every law that gets passed has to be in compliance with the Constitution because, as you may remember from other discussions we have in the Constitution, the Supremacy Clause, which talks about, federal laws may overrule state laws if there's a conflict, but in any event, all laws have to be in compliance with the Constitution of the United States. And so you pass a law in, say it's about voting. That's a hot topic today.
Certainly.
And it says that you can't vote at a, well, they actually used to have these laws. You can't vote or register to vote unless you sign and read and do whatever other requirements they had that were sort of racially based, prejudiced against allowing people to register to vote. And were those laws constitutional? And the suits were brought and they went through the federal court to the Supreme Court. Nope, that's not legal. It's not constitutionally, doesn't pass constitutional muster. So it's unconstitutional.
Sort of, not to get off the topic further, but reminds me of Obamacare. It's adapted, and then, of course, there's an issue about is this constitutional, and they're going to challenge that as they go along, too. But certainly it's interesting now to see that this new and final rule, regulation, let's hope that it does, they do follow up on it, and it does meet or it's complied with. There's a money component here. Those who are receiving financial support, colleges which are, they have to comply. Who isn't, and does that give them an out?
So it's an interesting question because if you accept federal funds, you have to comply with the law. And if you're a private institution and you don't accept any federal money and you want to have your rules the way they are, to some degree, you actually have some latitude. I don't think it's for all things because you can't still discriminate on the basis of sex or race or religion or any other protected class. But do you have to comply with Title IX if you don't accept federal money? That remains to be seen. And there are schools, a handful, not a lot, but some, that don't accept federal money.
I know when I read this, they did say that they are going to be changing the school's liability. And they're not really talking just about how many women are allowed to participate in sports or what proportion, but now, of course, this more encompassing issue about sexual discrimination, or more importantly, perhaps, sexual harassment, and that definition is being expanded. I can't imagine private, public, receiving federal funds or not, would want to dispute or tangle with this component because it's such a hotbed issue for all anyway. How you're going to define sexual harassment is getting down to the ands and the ors, apparently, not matters of syntax, but that is becoming a much wider net. Do you think that Title IX is now working in favor and is a better thing the way they're suggesting it right now?
You know, it's hard to tell until you see it in practice. So the law is written the way it's written, but how is it applied? And
yes.
So you have to wait and to see how it actually plays out.
So interesting. Without being political here, I know Betsy DeVos, the education guru under this current administration, had made a point of saying that now you have the right to face your accuser. If you backtrack for just a second, or maybe even decades ago, if a girl said a boy did a bad thing, the boy was out of sports, out of scholarship, possibly bounced. That was the end of it. It was cut and dried, clearly. Now they're saying this is going to change, and equity has a little bit of a different look, as in that boy now has a chance to say, I need and I have a right to face my accuser. And now they're talking about having the requirement of having witnesses, cross-examination, and that's parity too. That really is fair. Would anyone challenge? Why would anyone have ever challenged that that boy should have had a chance? I mean, it could have been the other way around, but for the sake of argument, for now, if the woman is accusing the man, then shouldn't the man have always had an opportunity to say, I beg to differ, that isn't how it went down?
Yeah, and as you said, and vice versa. But in any event, it seems on its face to be the right thing and to allow people to have their day in court, so to speak.
Yes.
And so it's hard to argue that that's a bad thing. But again, you have to wait and see how it's actually put in place and what procedures are put in place and how it's actually carried out. But if it's carried out the way you and I think the intent of it is, and it follows that, then how do you argue against it is correct?
Yes. So I understand there was one other element of it, which was years ago, decades ago, if one accused the other, in a school situation. The school said, let's keep it between ourselves. The school will take care of sanctioning the boy, sanctioning the girl, whatever it was, sanctioning the boy usually. And nothing else happened. He may have been run out of school, but that's where it was. And now there's an issue, and many are going back retroactively trying to raise suits saying that was never legal, that the minute that accusation took place, it should have had a hearing, it should have gone to the police level, never mind the internal official. And I don't believe they had Title IX compliance officers in those days because it was just so new, and I'm talking about the 70s, and who knows what's happened. I'm sure in subsequent years they did install that, but still it was kept in-house, so to speak. Now it's definitely, you make that accusation, we must call in the police and get others involved. That's the way it should be, should it?
There
correct?
were problems both ways.
Okay.
So way back in the day, when there was this underlying closely guarded secret about on-campus date rapes and all of these other things, and usually the woman, the victim of that, was pushed aside. Don't make a big deal out of this. Don't come forward. We don't want to hear about it. We don't want to deal with it. And the schools weren't dealing with any of those issues. And on the other side, when they were dealing with them, you could have had a college athlete on a, say, men's basketball team who's allegedly or accused of having done something, and it's just thrown out without his right to a hearing.
Yes.
So it's designed, hopefully, to fix both problems, which is, number one, make sure if someone is the victim of some crime, or at least alleged victim of a crime, that they're heard and they're not ignored and pushed aside and say, yeah, let's not talk about that. Let's deal with these things. But also, if we're going to deal with them, let's let the person who's being accused have his or her day in court and be allowed to say, no, that's not what happened. And that part of it sort of reminds me of the case against the Duke lacrosse team, where they were accused of, I think, raping a girl, and the team I think the whole season got ended. They got thrown out of school.
Oh.
And had to deal with that, and were exonerated after the fact, but had to deal with it for their lives, and probably many people don't know or don't care that they were exonerated.
Well, and that is an unfortunate fallout. I think there's probably going to be much more. So what happens while the schools are trying to comply, their budgets shrink? They have to shrink the overall athletic department, or put a lid on all of the sports that are going. So will that mean that they have to equally shut down not just the boys lacrosse field hockey, they have to do the girls too in equal measure? Is that the way that's going to go down under the consent decree?
Yeah, and under Title IX, I think you have to, just like you have your teams in place under Title IX with compliance with the law, in whatever ratio or compliance is particular to your school or specific to your school. If you're going to reduce, you have to do it in the same fashion. And add in the same fashion.
And add in the same fashion, too. So while they're talking about how they're going to gain the preponderance of evidence of budgets and how the decisions were made, or the preponderance of evidence about what this claim was against this boy, there's an issue about what preponderance of evidence is versus convincing evidence. What does that mean, David?
Clear and convincing evidence, preponderance of the evidence.
What does that mean
beyond reasonable doubt.
How is that going to play out,
so
David?
Those are the standards that we typically think of in different jury type of cases and so forth. So in a civil case, it's a preponderance of the evidence. In a criminal case, it's beyond reasonable doubt. And so what they typically would instruct a jury, they being the judges, on what is preponderance of the evidence is you take a scale, and the preponderance of the evidence means that if you add a feather to one side or the other side of the scale and it tilts ever so slightly in that side's favor, then they've met the burden of a preponderance of the evidence. That's one way of describing it. Clear and convincing, probably somewhere between a preponderance of the evidence and beyond reasonable doubt.
So when it comes to the very practical level of these schools enacting this, how are they going to be equipped? I mean, this is sort of rhetorical, I suppose, but how are they going to be equipped to defend and investigate and do this? This is going to mean, I guess, lawyers will be busier.
Well, I mean, there's, even leading up to now, with cases where someone's brought in front of the school board for a hearing, you know, whatever their disciplinary committee might be, or whatever they call it, there's rules that the school has in place that you're supposed to follow. And some schools, I've actually had cases for folks at some schools where they say you are entitled to an attorney, you can consult with an attorney, but they weren't allowing attorneys into the hearing. Nope, you're not allowed in here. They can come out, your client can come out and ask you questions if he or she wants. So how will it play out under these rules? Again, like we were saying at the very beginning, how this works is going to, or whether it's good or bad, is going to be very much on how it works in reality.
And another realistic issue to discuss here is Stanford and I think Harvard were having the discussions about who's going to serve as the judge, so to speak. Should it just and only be the ones who are in-house at the college level, or should you have someone from the outside, an external judge, a panel, a mix of both? at the practical level, how do you see that that would work best, David?
You know, I think that's going to be a decision based on what the school feels works for them. Do they want to put a dean and some other folks in that position to have to make that choice? Or would they be more comfortable saying, you know what, we're going to create a panel of independent people from the outside world, maybe retired judges, however they want to do it, and have whatever the process is, they have to first of all make sure it complies with the rules that they have to follow, and then they have to be consistent in following the process.
And how, again, at the practical level, how do they follow up on, investigate and follow up on what's considered to be a way to avoid sexual harassment and date rape and the rest by having a signed agreement every step of the way, so to speak, or before there's an issue? So at the practical level, there's a mixer, there's two people who get together, and I'm sure everyone has that paper handy. Are you sure, is this okay? And how is that ever going to be? We believe that people should not be chastised and harassed and the rest, but how does that play out, David?
Do we have a school handbook, and you're saying, are they supposed to carry the handbook with them and check?
When they're at the mixers.
No. Or are they supposed to just use common sense and decency and know what you're supposed to do in life?
And that would seem practical and reasonable, but they're actually talking about it being signed, something being signed. How can that happen, David?
Well, like at the beginning of a school year at some schools, you go in and you sign an oath to be honest and not plagiarize or whatever, or to act in accordance with the handbook. Or some schools have a handbook and they say, we want you to sign and acknowledge that you had the handbook and you read it. So that's really just more of saying that you're pledging to be honest, fair, and decent, and here are the rules, and you need to know what the rules are.
That seems minimally a very reasonable way of handling it, just as if you're taking a job and you're told that you can't discuss this, you can do this, and you've read the rules of the handbook and signed off. That would make perfect sense. It makes less sense when it comes down to each individual occasion or instance at which something can happen. And also tied into this Title IX, which brings up a question of how overreaching this can be. Many students go away for their junior year abroad to have a wonderful experience. That experience might have some issues, could be sexual harassment or some discrimination across the pond. How do they end up even dealing with Title IX regarding that? What is that umbrella covering, and is that also going to be a legal battle somewhere fought the minute someone said it happened across the pond and I want reparation?
It depends, I think, in some degree on what control the school that you go to has over the program you're in. So you went to Wheaton. I went to Trinity College, and we had a campus in Rome, the Barbary Center. And so I think if you went to the Barbary Center, the campus in Rome, and you acted in violation of the rules of Trinity College, you're still part of Trinity College. They have control and the right to do that. But if I created my own overseas program that had nothing to do with the school other than they were going to give me credit for it, it's less clear that the rules of Trinity might apply to that program. However, if Trinity's given you credit for it, they might argue, well, wait a minute, no, we approved this program, you still have to abide by our rules.
That seems like such a reasonable way of having that play out. I can only hope that it does. Of course, we don't really know. Whatever we have as a consent decree that operates under this school or that hearing or whatever that regulation is, does that also hold true across the pond?
So a consent decree from a case that was litigated in court
here, yes,
is limited to whatever the terms of the consent decree cover. So if the consent decree covers a program, it says all programs, including programs overseas, but it's not part of the school's program, I'm not sure the consent decree necessarily would cover that. But if you intend it to, you have to carefully word what is in the consent decree, like any other settlement.
So the devil's always in the details, and I guess here's an occasion where Well, I suppose the and or that they're talking about relative to Title IX and what do you consider sexual harassment or discrimination? They'll say this, comma, and that, which now may be this, or this, which certainly one makes it much more restrictive than the other and narrows down that definition. But it's
so and requires you to meet all
of
components.
them.
Or means any one of the components.
One or the other. Interesting. So what do you see as the next step with Title IX and how it's playing out? We know that there's a time frame, I don't know if it was 2029 or something like that, but then the lawyer said, and if there's any infraction on this new rule, we'll have them back in court again. Based on what you've read and what you hear, do you think that this is reasonable, that compliance is possible and doable and enforceable?
Yeah, well, it is. The question becomes, if you're making steps towards compliance and you're making all reasonable efforts and you haven't gotten there yet, is someone going to bring you to court and say, hey, you didn't comply yet? Maybe. But certainly what will happen is it has to play out first and see how people are interpreting what's required and how they're going to comply with it. And then if there's a group of folks who don't think it's being complied with correctly, you'll see a lawsuit.
I'm imagining we'll see a lawsuit somewhere. So another issue relative to all this, there's value in due process, as we talk about, that's part of the law. There's also value in protecting your privacy. These two things at some point seem to be completely at odds. The person who's accused, I don't know, let's come up with an example in this short amount of time that we have. The person who's accused has to have some time to go through due process, assemble his case, her case, or whatever, wants to keep it quiet, deserves some privacy, has a right to speak out, not speak out. Is this going to become a constitutional issue? How is this going to play out? How do you keep privacy and due process?
Yeah, so you can do both. Again, I'm going to just equate it to like a criminal case where most newspapers aren't going to print the name of the victim to protect his or her
Good
privacy.
point. That's a good point, yes.
So there are rules that you can put in place that follow that type of thing, that allow the accused to have his or her day in court and to be able to follow up on all the discovery they need to do so that they're able to prepare a case to defend themselves, at the same time protecting the person who's the victim from having his or her privacy invaded.
Of course, there's always comments and people spread gossip, and so that's one thing that's going to undermine privacy, but I guess that's not quite the same as when it becomes a legal issue. That's correct?
Yeah, it's not the same. You're comparing gossip to...
right, but it gets out, and it's certainly the privacy is making
it's invaded, but
invaded, and unfortunately you can't backpedal that once it's out, even for the bad news that Brown has had for its reputation being sullied. We hope that this has been interesting and helpful to you, as I'm sure we will be continuing the conversation about Title IX and other issues that matter. Please stay tuned to The Law Matters. It matters to you.